Counsel, each side will have 15 minutes to present their arguments to the court. The appellant may reserve up to 5 minutes, and just let us know, and we're ready to proceed when you are.
Thank you, Your Honors. I would like to reserve 5 minutes. I'm Ken Gibson here on behalf of the appellant Paul Miller. This case arose in a little bit unusual procedural context. There was a motion for 60B relief that was filed at the same time as a motion to modify spousal and child support. The trial court essentially bifurcated that and ruled on the 60B motion based on affidavits and did not hold an evidentiary hearing. The court then issued a order to the magistrate to conduct an evidentiary hearing with regard to matters related to the modification of spousal support and child support. The 60B ruling is not on appeal. It's not before this court. Only the construction of the agreement and the subsequent rulings of the trial court with regard to spousal support and child support and the defects in the orders are before this court. I mention this specifically because the appellee has attempted to introduce findings and evidence from the earlier proceeding, which the trial court specifically said would not be admissible in that proceeding, and which the magistrate and the trial court both disregarded and excluded. So there's a lot of evidence and facts and citations to findings in the appellee's brief that should either be disregarded or stricken because they are not part of the record in the motion to modify, and they are specifically excluded by the magistrate in the factual record. The magistrate said this is not an ambiguous agreement. I am not considering, in fact, she struck our attempt to introduce extrinsic evidence. So I've asked that those matters be stricken. I repeat that argument now. At issue in the first assignment of error is the construction of the parties' agreed judgment entry of divorce. The trial court found the agreement unambiguous, and as I mentioned earlier, excluded extrinsic evidence with regard to that. Therefore, the standard of review by this court is a de novo standard. It's the construction of a written agreement. The construction before the trial court, and that's been raised here, turns on the meaning of the term net income. Appellee concedes that the ordinary meaning of net income would exclude actual taxes paid by the appellant. However, the appellee argues that somehow the agreement as a whole indicates an unambiguous intent to modify the ordinary meaning of net income to something else. And that really is not availing to the appellee and is not a proper basis for the trial court's decision. The trial court, in saying net income, didn't give any kind of analysis as to why net income, the ordinary meaning of net income, should be thrown out. I mean, didn't point to any case law, didn't point to any language in the agreement. You know, it was just, oh, we don't think this is fair or something like that. I'm sorry, did you have a...
I do have a question. I was thinking through this, and I'm thinking when you write a separation agreement and you assign, you're going to be responsible for this credit card and all the interest that goes with that credit card. After the fact, you don't come back and deduct the interest off because I had to pay interest on it. In this case, the taxes were due on a lump sum, i.e. the credit card balance.
The appellee argued that essentially the taxes were part of the debt. Okay, and I think that's what you're essentially saying. Well, interest is part of the debt. Okay, if you look at a debt, if you have a note the interest is part of that debt. But taxes are not part of the debt obligation. It's something entirely different. It relates to income. The tax, there's a part of this agreement between the parties that relates to property division and the assignment of liabilities. And he was liable on this debt. And there's no question about that. In fact, the evidence in the record shows he actually had to pay on it, even though it was going to be forgiven normally if he met certain performance bonus criteria, because he didn't meet those criteria. So it's a debt, but the taxes are not part of that debt. It's not a debt to the employer. It's an obligation to the United States government or the state government. And so I think that that's a significant distinction. It does, the agreement in using the term net income says clearly and unambiguously, in our opinion, and in the trial court's opinion that it was clear and unambiguous, it just came to a different result, that after the taxes are to be excluded from that calculation. Now in the gross income, the parties had to expressly say, we're excluding $200,000 of gross income because he didn't actually get it, okay? Because the definition of gross income, as the appellee points out, might include forgiveness of indebtedness. The statutory definition is broad enough that it might include that as gross income, so the parties had to exclude it in their intent, in their agreement, and they did. And everybody agrees that they did. But they didn't have to go further and say, well, we're excluding the taxes from net income because the ordinary meaning of net income is after taxes income. So there's no inconsistency between including gross income and excluding a portion of it and then using the term net income to refer to after-tax income, which was to be equalized by the parties' agreement.
Now, I understand the position that you've taken that some of the facts that were set forth in the opposing brief should be excluded, but assuming that we do not agree with you on that legal point, can you address some of the statements that your client made indicating that he was considering tax implications?
Well, let me tell you this. He tried to explain what the intent of the agreement was, and that evidence was stricken by the magistrate. So I don't have anything in the record that reflects his explanation of those because he never had the opportunity to explain them to the court below.
Were there emails that were included in
those were not exhibits in the hearing. The emails were excluded by the magistrate as evidence, as well as his explanation or attempt to explain the interpretation of the agreement. So I don't think I can give you an explanation of the emails because there's nothing in the record because the magistrate and the trial court said we're not considering that. And if you look at the original decision of the trial court acknowledged that this would not be admissible for the interpretation of the agreement only as it relates to the issue of the 60B motion. So that's all I can say to you on that.
So how do you explain away that indemnify and hold harmless on the ramifications of that $200,000?
Sure.
I'm understanding that they're including the taxes that come attached to that as being part of what you're holding her harmless from.
Your Honor, again, you need to consider the distinction between the property part of the settlement and the spousal support. The debt was assigned to him. He had the obligation to pay the debt. He also had the obligation to pay the taxes. The IRS, if they came back to her and said, we want taxes, which they couldn't really because they were filing separate in the years in which he had to pay those taxes, but he would have to pay them. But that doesn't mean that when you go then further, after the property settlement is done, then you go to the spousal support and the child support. And in considering the spousal support and the child support, the terms of the agreement say that you use net income, which is after-tax income. That's the meaning of those terms. So to say that he had the obligation to pay the debt or pay the taxes is different from saying that you can exclude that or should not exclude those taxes in determining what his net income is. I mean, it's an entirely different section of the statute that relates to that.
And counsel, you're in your rebuttal time.
Oh boy, I'm sorry. Let me use just 1 or 2 minutes of that rebuttal time. As it relates to the issue of the federal statute, to the extent that just by this court suggests that the trial court has no responsibility to ensure that its orders comply with federal statute, it's contrary to the express language of that statute. And I don't think that's what Jess says, but to the extent that it does say that, it can't be good authority because it's contrary to federal law. And I'll rely on my, I just want to mention, the trial court modified child support without either notice or a pending motion to modify child support. Not to say that the circumstances hadn't changed that would allow that modification, but the appellant was entitled to a motion that invoked the court's jurisdiction and entitled to notice that the court was going to do that and to present any questions or arguments that he might have regarding deviation factors or any other defenses, and he didn't have that opportunity. So we believe that's error too. Those are the 3 assignments there.
Thank you.
Thank you.
Morning, Your Honors. May it please the Court, my name is Richard Marco, Jr. I represent the appellee in this case. This is kind of an unusual case, and I would say that the attempt by the appellant to micro-interpret portions of the agreement without the entire agreement being before it are what has created the extreme amount of litigation in this case. I mean, I think you have to really go back to where this case came from. These parties came to an agreement, and their agreement was laid out in a document that obviously was ill-written. We'll just put it that way. Right? But
I didn't hear that.
Ill-written.
Yes.
But the intent of the document and the circumstances of the parties were pretty clear. Those were the things that were clear. To say that the judge did not have to interpret this document is not correct. In fact, Magistrate Muscola on page 14 of his decision said, we have to define what the parties did not define so that we can put together a right result in this case. So this document, which, again, ill-written, undefined portions of it, means that the court went through an analysis of the document that had to take into consideration the whole penumbra of items that were before it. If you read the transcript, and I don't know the page, you'll see that we asked, is the law of the case going to be utilized in the analysis of this motion for modification of support? The law of the case was Judge Kovac's decision that included the 60B ruling, wherein she made findings of fact concerning the father, let's say the husband's knowledge in this case of tax consequences. The parties chose, in doing their agreement, to modify the terms of gross income. Parties at the same time, by removing gross income, you also modify net income at the same time. You can't say gross income is modified, net income isn't modified. And what was the intent of the parties in doing so? That's why those emails that are contained in Judge Kovac's order, which is part of the case before you, that said, I knew what those tax counts were, and those are mine. By the way, stay away from the proceeds of my retention bonus.
You started out saying that you asked if the law of the case would be applied,
Yes.
including the 60B ruling, and what was the response?
From the magistrate was, we look at the entire file. The point of it is that you can't take it in isolation, and that's what they're trying to do. That isolation is what injures my party. There was nothing different from the time they signed that divorce decree. There was nothing different.
How do you respond to the husband's argument that the court had stricken certain evidence, and he said that the evidence was restricted just to the 60B motion, but was not to be applied to spousal or child support?
First of all, I don't believe that to be true. I believe that the court indicated that it was going to accept all of its rulings in determining what the impact was of the separation agreement on the motion for modification and support. Having had those findings already made by the court in the Rule 60B, we didn't submit any farther with respect to the evidence that was being presented to the court. And the issues were concerning whether there was any different expectations with respect to those taxes. Let's face it, this case is all about those taxes on that retention bonus. That was $1.3 million. If you look at the document itself, Your Honor, you will see that the separation agreement and the child support worksheets that are attached to it do not include the taxes on that retention bonus. They do not include it. That entirety of the document is one of the rules of construction when you look at what is the parties' agreement. What is the agreement that they reached? The agreement was clearly that we had to leave the retention bonus alone. We weren't getting any part of the proceeds that were left of that. So leave it alone. The retention bonus payback is not, he does not have to pay the $50,000. He has to pay the taxes associated with the $50,000. If you liken it to a credit card, that's like having an agreement that says, you owe me $20,000 on a credit card, but I will forgive $5,000 a year. You just pay the taxes. He's not paying back the $5,000. He's only paying the taxes. That is the repayment of the debt. Now, if you don't meet your production, then you got to pay. Okay? Happened one time in the 4 years that they were talking, out of the 16 quarters. And that, unfortunately for us, got reflected in a reduction during that period of time of the child support and the spousal support. So he's got what he wanted there. Our point of the document is that it said, I will pay you $10,000 a month regardless of what happens. Regardless of what happens. The court said, we got to look at what was in there, so they took his income at $600,000, which he never made at the time he entered into that document. He was not making $600,000 when he agreed to an imputed income of $600,000. He was making the exact same amount that he made in year 2, in year 3, and probably in year 4. He made a bad deal and wants out. That's what this relates to. The guy makes $500,000 a year and he wants to pay $1,800 a month in spousal support on an income equalization theory. That's not right. We have to look at the document as a whole. Again, they entered into an agreement. The ancillary documents to the agreement, which were part of the court record, show that taxes were excluded. The intent of the parties was, because he said he had a mistake of fact in the 60B, we can't just throw that out. Did you not know about the taxes? Yes, I knew about the taxes.
Let me ask you a question. When you first put the separation agreement, or when it was first put together, I'm presuming there was a child support worksheet attached to the original
Yes, Your Honor.
bunch of documents. Was the taxes included in that original worksheet?
It was not. Neither was the income. The $200,000 was removed, but so were any taxes associated with it. It is part of the original judgment. That was our point, is he always knew that those taxes were his responsibility. And again, I would add on, it's because those taxes were the repayment. There was no repayment of that loan. And it's also because, as we point out in 60B, he got the proceeds that were left of the retention bonus. Leave them alone. It's in the record of the court. Leave the retention bonus proceeds alone. You know you can't pay the taxes to keep those things. What's the implication? An unequal division of property based upon what's going to happen in the future. My client sitting here, she can make $60,000 a year, having been used to a lifestyle of $500,000. Was $1,800 a month in spousal support really a fair result from that? We have to look at the document. What is the intent of the party? We believe, going back, that the intent of the party is, I'll just pay you $10,000 a month, whether we call it child support or spousal support. And I'm not sure where my time is, but getting quickly to some of the other issues. The court issued a wage withholding order because Mr. Miller agreed that if he did not make his spousal support payments for 2 months in a row, which he acknowledged at the first hearing on that issue, that an affidavit submitted by Mrs. Miller will cause the court to issue a wage withholding. That's what happened. Now, whether he proved to his employer that his disposable earnings, because that's the basis, not your net earnings, but your disposable earnings, was somehow impacted beyond the federal guidelines, that was his responsibility. And that's where the court is correct. You didn't say anything about disposable earnings. You just want to go by net. What is disposable? He was getting a $50,000 reduction in a debt. That's disposable earnings. He was contributing to a retirement plan. That's disposable earnings. He was paying for HSA, health insurance, all of those things that are on his pay stub. Those are disposable earnings. He's just going to one line at the bottom after his chosen deductions were taken and saying you violated. That's why it wasn't the court's responsibility. It was his responsibility. But Mr. Miller chooses to put his responsibility on other people. As far as the spousal support, no motion. There was a motion to modify spousal support. The spousal support and child support order was $10,000 a month. It wasn't for a specific period. It was $10,000 a month for the entirety of the term of the spousal support. Now, if you say that there was no motion, then the spousal support should have returned to the $10,000 a month, as opposed to being reduced. I don't know what their argument is on that one, because the document says, in the absence of modification, this is what it's going to be. It doesn't say what it's going to be is going to be related to the prior period. It says for each period of time, which has to coincide with the emancipation of children, you're going to owe $10,000 a month, and we're going to divide it between child support and spousal support. I think the court did them a favor.
And you're not making any motion on your part that the court was wrong by modifying it below the $10,000.
Correct, Your Honor. But if it goes back, then I feel that should be an instruction. I don't think the case should go back. We have fought and fought and fought. I mean, this lady who doesn't have anywhere near the resources, and you see in the order, and I know this may not be directly related, but he took the kids' college funds to maintain his litigation expenses. She paid hers out of whatever she had. Sometimes you don't have enough to pay for everything you got to have. She was receiving, if you notice in the record, when she was entitled to receive $120,000 a year, she was receiving $40,000, $50,000, while raising 4 children, high school age, and trying to live in a house that they had maintained at $500,000 a year. Sometimes things have to give. In this case, Mr. Miller has to give. He was successful in getting the benefit of his bargain modified by the court, because the agreement was inartfully wrong. But truth be told, by everything you look at, his obligation was $10,000 a month, and by the emails that are part of the court's own record, he didn't care about anything else until he got her signature on the document. And and then came in weeks later, and has been back in court monthly since then. This is not a fair result. The court issued orders that are based on actual income, and that's why my client was willing to accept it, because that's what it is. But that was not the agreement. But it is the court's interpretation. The court's interpretation is based on an ambiguity that is created by the circumstances of an entry that was negotiated at the last minute.
But did the court in fact say that the agreement was unambiguous?
The court, when he said that, I looked back through the entries of the court. I did not find it. I did not find that in Judge Kovac's order that was issued in 2014. I did find on page 14 of Magistrate Muscolo's order that he said we have to define what the parties have not defined. That to me is saying the same thing, that it's an ambiguity. Because if it's subject to differing definitions, then the court has to step in and define. And what Magistrate Muscolo said is we took income out, and I think we took taxes out, and here's some of the reasons why we did. And one of them being that the document itself, the separation agreement, with the attachments, which was the child support worksheet, removed those taxes from consideration. It was basically saying we're going to take his income from earnings, not from his bonus, and we'll utilize that. Your Honors, I feel strongly about this case that Mrs. Miller should prevail on this appeal. It's been difficult for her to maintain the fight. Again, the entirety of the record is yours for consideration. I know that they like to pick and choose which parts you look at, but I think you have to look at the docket and the words of the court as a whole in this case, in addition to the evidence. And I think you will find that in the absence of a determination of $10,000 a month with somebody who was stuck with, the next option would be that we take the party's actual income, remove the $200,000, which was the retention bonus, remove any taxes from consideration, since that's his payback method, and determine what the income is from there. That was the option that the court chose, and that frankly we felt that perhaps based on the standard of review that would not be a successful appeal. So we're here defending the appeal at this point in time. I appreciate your time.
Thank you.
Thank you.
You have a little over 3 minutes.
I hope I have enough time to address all of the mistakes or misrepresentations made by the appellant in the oral argument. First of all, he implies that there was some proceeds left of this retention bonus that he negotiated to keep. The evidence before the magistrate and the trial court was that the retention bonus was received when he got the job, and that it was divided and spent long as part of the agreed on division of assets. There was nothing left. Okay, second of all, there was a representation that his income was like $500,000. That's not true. It was $600,000 in the original, and there was testimony that if you exclude the taxes, it's down to about $121,000. So it's not a $500,000 income. Even if you include the taxes, it was a couple $100,000, not $500,000. Third, he had checks, and he presented copies of checks to the court below showing he had zero income from his net income from his paycheck, because they were taking it all. The retention bonus that was being paid back was not a voluntary thing. It was deducted by the employer before he even got a penny. The motion to modify spousal support was pending before the court. There was no motion to modify child support as of the date of the emancipation of the children. So the motion to modify spousal support was properly before the court. But when the court modified spousal support, it also modified child support, and that's the complaint, because there was not even any notice that the court was intending to do that. nor did the court have any jurisdiction to do it based on any pending motion to modify child support. The motions to modify were all spouse support, or as it related to different periods of time. I mean, he did make a motion to modify child support, but it was based on an earlier period. There was no motion to modify as of that date. The attachment to the agreed judgment entry in the form of a child support worksheet showed his income at $400,000 and her income, including spouse support, at $107,000. It does not specifically make a adjustment for extraordinary taxes, but it doesn't exclude that either. It just says, here's his income, here's her income, do the math by a calculation.
But there is a line on there where you can put miscellaneous deductions, and if they wanted, if you intended to deduct the $58,000 in taxes, it could have been added as a separate line item, reducing his overall income in the left-hand column.
There is a line in there that could have been used by the parties if it was needed to do that, but because they used the term net income in their agreement, I'm suggesting that they didn't need to do that. The changes of circumstances were not just the fact that he had to pay these taxes. We knew he had to pay these taxes. Okay, the change of circumstance was the fact that there was a substantial reduction in his income and a almost doubling of the imputed income with the wife's new job.
Was the $58,000 in taxes deducted out of that $400,000 on that initial worksheet?
There's no, other than the worksheet itself, there's no evidence in the record one way or the other on that.
So we don't know whether the 400 included the 58 or only the 200?
We know that the 600 was taken down to 400.
Because of the 200?
Because of the 200
But there wasn't an additional 58 taken off of that?
Well, we don't know what the taxes were in that particular year. It depends on, okay. I mean, you know, it just is what it is.
And we're out of time. Thank you very much for your presentation to the court. Thank you both for your presentations to the court. The court will take the matter under advisement, and a written opinion will be sent to both sides, as well as you can look on the website of this court and the Supreme Court.